Okay, so what I would like to look at now is the court system and in particular the court hierarchy. And this is really important in relation to our next lecture on judicial precedent. So judicial precedent only operates in the context of the court hierarchy, and it's really important you get an understanding as to the way that the court system works. So our learning objectives then are, first of all, is to understand the court structure within England and Wales. So hopefully at the end of this you'll be able to explain to somebody who asks how the court structure works in England and Wales. You should be able to explain how it works and have some understanding of that. You'll then be able to assess the functioning of each court to show how it works and to assess the workings of that court, in particular in relation to criminal and civil law and how they work, how the two types of courts work. And then you'll be able to assess the influence of other jurisdictions on the court system. So we'll have a look at, in particular, the courts, how they work in relation to Europe, so the European Union, and the European Court of Human Rights, and also we'll look at the Privy Council as well and the influence of those. And these are important as well for you to get an understanding of in relation to our judicial precedent lecture. So our agenda then, how we're going to reach these objectives, is that we'll look at the court hierarchy, and then we'll look at the division of the criminal and civil courts as to how they work, the role of the appellate courts, so the Court of Appeal we'll look at, and we'll look at the Supreme Court, and then we'll look at the influences of the Privy Council, the Court of Justice of the European Union, and the European Court of Human Rights. So this diagram then is really a diagram of how the court structures work. So at the top we have the Supreme Court, which as far as civil cases go is the final court of appeal for the whole of the UK, and for criminal cases it's the final court of appeal for England, Wales and Northern Ireland. And then we have the Court of Appeal, which has two divisions, and the Court of Appeal is lower than the Supreme Court. So we have a criminal division and we have a civil division. So you would have learnt in your previous lecture that the differences between the criminal law and the civil law, and there is a division for each in the Court of Appeal. The High Court, which is quite a complex court and covers different areas and has different functions, and it has a number of functions. So there is the Queen's Bench Division, which deals with the contract and tort and commercial courts and elements of admiralty. We have the Administrative Court, which is supervisory and an appellate jurisdiction, overseeing the legality of decisions and actions of inferior courts, tribunals and local authorities, ministers of the Crown and other public bodies. So there is an appellate element to the High Court. There is a particular division that deals with family law, and there is the Divisional Court, which deals with appeals from magistrates. So there's an element of criminal appeals that comes from magistrates, particularly in the context of sentencing and those sort of things. Then we have the Chancery Division, which is equity and trusts, which you'll certainly go to learn more about in your second and third years. And things such as probate, tax partnerships, bankruptcy, there's a division for that. And then there's a divisional court, appeals from the county court in civil law on bankruptcy and land. So you can see it's multifunctional. The High Court is quite a complex court, and there's a lot going on within the High Court. On the criminal side, the lower courts are, we have the Crown Court and the Magistrates Court. Now, if you're arrested, if you have the unfortunate circumstance you're arrested and you're charged, you then appear before the Magistrates Court, irrespective of the seriousness of your offence. So, you know, the most serious, heinous crimes of mass murder, for instance, will start off in the magistrates' courts. The trials, as far as trials go, if you've got a serious offence, if it's indictable, or it goes either way, then it will do more about that in a little while. It will go to the Crown Court, who have the power to sentence more than 6 months, whereas a magistrates court, their sentencing are limited, so by that nature they tend to deal with lesser offences, less serious offences at trial. There's also an element of the magistrates court that deals with family proceedings, and there's an element of it that deals with youth courts as well. So youth courts dealing with offences caused by minors, etc. is dealt with in the magistrates court. As far as civil law goes, we have tribunals. So they may have a particular specialism, so immigration or employment, for instance, are very typical tribunals where you can have your case heard. And then we have county courts, which is really essentially the majority of civil litigation, depending on the particular nature of the claim. If the claim is quite a complex claim, or if it deals with a lot of money, then we're going up to the High Court, and we'll talk a little bit more about that in a little while. On either side here, we have the Privy Council, which deals with cases coming from some Commonwealth countries. It's the final court of appeal, and very typically those that sit on the Privy Council also sit on the Supreme Court, so their decisions are seen as being hugely influential. However, they do refer to the Commonwealth, but their decisions are seen as being persuasive on some of the lower courts, although there is not a duty to be bound by the Privy Council. We also have, as what was known, the European Court of Justice and the European Court of Human Rights, now referred to as the Court of Justice of the European Union. And the European Court of Human Rights. These are two distinct courts. They are separate. They have nothing to do with each other. It's important that you note that. And the only thing they have in common is the word Europe, but they are different, and we'll look at the functioning of those in a little while. So let's deal first of all then with the criminal court structure. So the magistrates court deals with 98% of all criminal cases. There is no jury at the magistrate. It is the magistrate that gets to decide whether you're guilty or not guilty. Though they are accompanied by advisors, and there is a clerk that accompanies them on areas of law and guides them. They are lay magistrates mainly. And what a lay magistrate means is they don't have any legal training in the sense of they haven't got law degrees or anything. They are lay people. They're seen as peers, and often done on a voluntary basis, with the exception of district judges who are paid magistrates. And you see a lot more district judges in particular in London, and they are paid magistrates rather than lay magistrates. They deal with summary offences, so lesser offences, and some either way offences. So there are some offences that sit across both summary and indictable, and it's up to the magistrates to decide on a case by case basis on that as to whether to refer those cases to the Crown Court. In the Crown Court, these are trials of some of the most serious criminal cases which can be indictable or some either way offences. It is the jury that determines questions of fact in a Crown Court. They determine guilt, however it's the judge that determines the sentence, and also the judge gets to decide on the points of law that are allowed into the case. It's important to note, as I mentioned on the previous slide, that the High Court does deal with some appeals from the magistrates as well, which we can see here as part of the court structure. So then we have the civil court structure. So the county court is the lowest level of civil court. So if you have a claim, you go to the county court. If it's a simple case, relatively simple, quite often county court claims are done online. These days you can do your claim online and it's issued online, and it deals with 97% of issued claims. We have the family court, which deals with divorce, for instance, child protection and adoption issues such as that. And then we have the High Court, the three divisions of the High Court, which deal with civil claims. There are the Queen's Bench for Division for Tort and Contract claims, the Chancery Division for things such as wills, probate, trusts and land, etc. And then the Family Division dealing with the most serious of family cases. So then we have the Court of Appeal, which the appellate courts, the Court of Appeal and the Supreme Court in particular, are probably going to be more of interest to us as law students and as academics, because that is where the points of law get decided. So when a case reaches the Court of Appeal, they decide on a point of law. That is with the exception of when appeals are made in relation to sentencing, for instance. But on points of law, the Court of Appeal gets to decide points of law, and very typically the parties to the case are not involved anymore. There may have been a mistake made at one of the lower courts on a point of law, and the Court of Appeal gets to decide on that point of law, and the parties are simply there to hear the decision. They don't need to bring in any more witnesses in relation to that, except there is an arm of the Court of Appeal that's related to appeals against miscarriages of justice. So there is a section of the Court of Appeal that does deal with that, and they may consider new evidence, etc. However, for the purposes of your study, you won't necessarily be dealing with that in your studies. What you will be dealing with is the Court of Appeal as its function in appealing points of law. So these are the heads of the division. There is a president of the Queen's Bench Division 2, a president of the Family Division, etc. And there are 38 Lord and Lady Justices of Appeal, is what they are referred to. There's a criminal division, there is a civil division, and they get to decide, for the purposes of your studies, they get to decide the points of law. If, however, the Court of Appeal gets something incorrect on a general point of public importance, it then goes to the Supreme Court, or what used to be the House of Lords, which we'll go on to consider now. So the Supreme Court then, formerly the Appellate Committee of the House of Lords, since October the 1st, 2009, is the final Court of Appeal in civil and criminal cases for most of the UK. The Constitutional Reform Act of 2005 put it into place that there would be a creation of a new Supreme Court, which instilled the independence of the judiciary on a more stronger footing. And very typically before that, the final Court of Appeal was the House of Lords, which of course also serves as the upper chamber of the legislature. In its judiciary function, it had served as the final Court of Appeal. It was held in the same place, despite the fact that it had a different function. And to reinforce the idea of judicial independence, it was seen that there should be a new building and new justices, and we have now the Supreme Court. It hears appeals raising points of law of general public importance, so not all appeals on points of law it considers. So it receives very typically 200 applications, but it hears 60 or so full appeals. There are 12 judges, of whom normally, on most cases, 5 normally hear appeals. Exceptionally, there are 7 or 9, and very exceptionally, there is a full house in relation to really serious matters of public importance, such as the most recent Miller case in relation to the prorogation of Parliament. But very typically there will be 5 justices, and if 3 of them vote one way to the other, we then have a decision in favour of the majority. So the judgments, you will read a leading judgment. You will typically see a couple of other judges quite simply saying they agree with the lead judgment. They may have a point of law to express themselves. A minor point that they may differ on with the other 2 majority justices, so they may want to write a little judgment themselves. However, very typically there will be one lead judgment to avoid any confusion amongst the majority judges. You'll also get to read dissenting judgments, so those that disagree will get to explain why they disagree and how they disagree. And those dissenting judgments in themselves are quite interesting to read and will allow you to critically evaluate the case that you're reading at hand. So the current president then of the Supreme Court is Robert John Reid, and he's taken over from Lady Hale, who has been quite a well-known and famous president of the Supreme Court, not least because she was the first woman justice on the Supreme Court, and certainly the first woman president of the Supreme Court, and she's giving some fantastic judgments in recent years and will no doubt go down quite a famous president of the Supreme Court, quite a famous justice. But now we have Robert John Reid. It's also worthy of note to point out the Judicial Committee of the Privy Council acts as a final court of appeal for some Commonwealth countries, overseas territories or Crown dependencies. So Crown dependencies, by way of example, Jersey, Guernsey, Channel Islands, those sort of places. Some overseas territories that we have, and some Commonwealth countries is the final court of appeal. It is comprised of the justices of the Supreme Court and maybe some others who have held high judicial office. Because of that, their decisions are seen as being highly persuasive on areas of law, but lower courts are not bound to follow. The Privy Council, there is no duty, but quite often we have seen cases that have followed Privy Council decisions, and they are seen as hugely influential. Then we have the Court of Justice of the European Union. Of course, there have been some big changes over the last year or so in relation to the Brexit vote. Their jurisdiction is to interpret European Union law, which is a block of what is now 27 member states. The UK was part of the European Union since 1973. And the effect of the particular section of the European Communities Act meant that there was a mandatory incorporation of EU law into English law, and so that was incorporated. However, since Brexit, there have been discussions as to the extent that the Court of Justice of the European Union has a bearing on, in particular, the trade relationship between the UK and the European Union bloc. However, exactly what's going to happen remains to be seen, because it's still part of the negotiation process. That is something that is a wait and see moment. Then we have the European Court of Human Rights, not to be confused with the Court of Justice of the European Union. They are distinct, very separate institutions, have absolutely nothing to do with each other in that context. It governs the European Convention of Human Rights, which is a document that states signed in the aftermath of World War II to enforce, so that people could enforce their human rights against their government or against the state. And the European Convention of Human Rights has been in force in all that time, right up until the difference being, well, it's always been in force, but the difference is under the Human Rights Act that can now be implemented into domestic law, into domestic court. There is a duty of domestic courts to take into account a judgment, decision, declaration or advisory opinion of the European Court of Human Rights. What that phrase "take into account" means we'll explore in a later lecture when we consider how the courts interpret the law by taking into account these judgments. So by way of summary, we have looked at the court structure of England and Wales. We've examined the functioning of each court, particularly in relation to criminal law and civil law, and then we've assessed the influence of the Privy Council, Court of Justice of European Union and the European Court of Human Rights. It's important that you get a good understanding of the way that the court hierarchy works, particularly in relation to our next lecture on the judicial precedent. So our final thought goes to French philosopher Michel Foucault, who says the court is the bureaucracy of the law. If you bureaucratise popular justice, then you give it the form of a court.
Hello and welcome to this recorded lecture for the University of London undergraduate law program. My name is Ioannis Glinavos and I will be your tutor for contract law in this study event. In preparation for our live sessions, you are invited to watch this video, do the recommended reading and attempt the exercises that have been communicated to you already. This lecture focuses on one of the key elements of the study of the law of contract, the treatment of what are known as limitation, exclusion or exemption clauses. These are clauses that try to limit or totally eliminate the liability of a party in case of breach or deviation from contractual performance. A typical clause most of you will be familiar with is one that says, You are parking the car at this location at your own risk. The parking garage will accept no liability for loss or damage to your vehicle while in our premises. Such a clause may be found in a notification displayed at the location of a car park, or on a flyer or on a receipt. Exclusion clauses are legitimate ways to apportion risks of loss between the contractual parties, but need to stay within certain boundaries to ensure their effect. One could argue that the cost of obtaining a service could be higher if the supplier was not able to manage the risk of monetary loss arising from customer claims. On the other hand, as most of these types of clauses are inserted in standard form contracts, those are prepared in advance of meeting the customer and not subject to negotiation, there's a high risk that they might be unbalanced and unbalance the relationship in favor of the supplier of a product or service. This is why there's quite a lot of detailed legislation regulating the form and content of exemption clauses, especially in the area of consumer contracts. This lecture will discuss the place of limitation and exemption clauses in English law, presenting their nature and functions, the way the law treats their incorporation into the contract, case law, and statutory controls. We touch upon the treatment of such clauses both in the case of consumer and in business-to-business contracts. This lecture starts by discussing how limitation clauses are incorporated into contracts, addresses their interpretation through the concept of construction. It then proceeds to discuss the statutory treatment of potentially unfair terms through the Unfair Contract Terms Act of 1977 and the Consumer Rights Act of 2015. Hello and welcome to this recorded lecture for the University of London Undergraduate Law Programme. My name is Ioannis Glinavos and I will be your tutor for contract law in this study event. In preparation for our live sessions, you are invited to watch this video, do the recommended reading, and attempt the exercises that have been communicated to you already. This presentation offers a summary of the main aspects of contractual formation. The presentation is divided into 4 sections. We start by presenting the law in relation to offer and acceptance. We proceed to discuss the tricky concept of consideration, and we conclude with an overview of intention, certainty, and completeness. I hope you find the presentation useful, and I'm looking forward to meeting you online in our live event. Hello and welcome to this recorded lecture for the University of London Undergraduate Law Programme. My name is Ioannis Glinavos and I will be your tutor for contract law in this study event. In preparation for our live sessions, you're invited to watch this video, do the recommended reading, and attempt the exercises that have been communicated to you already. This presentation offers a summary of the main aspects of the doctrine of misrepresentation. We will see what is an actionable misrepresentation and will discuss potential remedies such as rescission of the contract and damages. Finally, we will present how any attempts to exempt liability for a misrepresentation can operate under the Unfair Contract Terms Act of 1977 and the relevant provisions of the Consumer Rights Act of 2015.